some time ago, long before I did my presentation. I was relieved when you went through it that I've actually covered, I think, what I said I would cover, so we're off on the right foot. I think that it is generally accepted that the trading conditions for our industry over the last 5 years have generally been tougher than in the preceding 5 years. Now, there are obvious exceptions for individual businesses, but for an industry as a whole, I think that's generally accepted. What I don't think is understood is that the trading conditions in the next 5 years, as John alluded to, are actually going to be a whole lot tougher again. And I think in all likelihood the trading conditions in the 5 years beyond that will be more difficult yet again. I think we get through that period and things might start to plateau and turn, which, yeah, that's terrific news, isn't it? It's only a decade away. And there's a very, very simple reason for that. And that reason is that for the first time in the long history of a venerable industry, we are facing competition. Now, many people will sort of nod and say, yes, competition, I know all about that. I've been competing my head off for decades. I know exactly what you mean. Well, I'm sorry to say that you don't. Because what we have experienced throughout our working lives is not competition. It's what I would describe as the gentlemanly jostling for position in a protected industry. It is not competition as the rest of the economy knows it, but that has begun to change and will continue to change at an increasing pace. Today I want to run through a bit of an introduction, as a little bit of background about me and why it is that I've come to understand some of these things. I want to talk about some of the supply side factors and demand side factors that are the catalysts for this new age of competition, a new wave of competition that we're going to have to get used to. And with a bit of understanding about what's driving this new wave of competition, I want to talk about the impact that that competition is having on our markets, and I want to leave you with 4 questions. I'm sorry I don't have the answers for you. You'll have to work them out for yourself. But I want to leave you with 4 questions which I think are absolutely essential for any business which is serious about not just surviving, but surviving and thriving in a new age of competition. And as John rightly pointed out, there are going to be all sorts of extraordinary and exciting opportunities for those who are prepared to take them. I founded our business, Kain C+C Lawyers, about 9 years ago. We are a specialist legal consulting company based in Adelaide. We work right across Australia, though we're based in Adelaide. We work purely in corporate, commercial and M&A law. And we were founded in about May of 2004, after I'd worked for nearly 15 years, predominantly in corporate law and as a partner in 2 partnerships in Adelaide. And there were 2 really fundamental things I learned on that journey leading up to the establishment of our business. The first was I learned in a professional sense, not in a physical or spiritual or other sense, but in a professional sense, I learned why I existed. I learned why I got out of bed in the morning and what I wanted to achieve out of work. The second thing I learned was that partnerships are an appalling business structure and make it very, very difficult to do innovative and courageous things. So, armed with those 2 pieces of learning, I sort of hung a shingle up on my own a bit over 9 years ago. But there are 2 fundamental things which we put in place in our business that have sort of put us on this path and helped me come to understand what's happening in our industry. As I came to recognise what was going on in the industry, or going on in what I wanted to achieve in the industry and how I could express that. I was faced with 2 options. One was I could try and change the partnership in which I sat at the time from inside. I'd tried that already and had failed in 2 partnerships. Or I could have gone into a 3rd partnership and 3rd time lucky, tried it. I didn't think that would work. That would be, in Henry Ford's parlance, that would have been trying to breed or train a faster horse. So instead of that, what I chose to do was try and invent a new model, a brand new motor car, and hope like hell I didn't wrap it around a tree. So that's what led to us being established. We were established with 3 very clear goals, which are very clearly enunciated and embraced by every person in our team. We are established with a very clear structure. Now, there's nothing particularly surprising about this. It's a structure that 99% of our clients would use. We have shareholders, and they have a very simple role. Their role is to provide capital and appoint the board. We have a board, and it has a very simple role. It's to set the strategy of the business. Management has to execute the strategy, and the team delivers service. Now, lawyers are obviously interested about their professional fulfilment and all sorts of things. They're also reasonably interested in money. So another thing we've done in our business is create a very clear understanding and distinction as to where you get your money. You can get your money as a return on capital, or you can get your money as a return on labour as an employee, and never the twain shall meet. Excuse me, even though you might be both an employee and a shareholder. Now, that's all terribly interesting, but its relevance to today is our board and its role. And it's a useful demonstration, I think, of how the right business structures can help to lead to the right business outcomes. So our shareholders' agreement requires a majority of independent directors, and it requires an independent chair, and our independent chair, Mark Booth, is here with us today. So I'm the only executive director on our board. In 2011, in the calendar year 2011, our board identified that things were changing in the industry. We didn't know quite what or how or what the impact would be, but we did know in our waters, as it were, that what was happening was not simply a result of challenging economic conditions, which, if you think back, was the generally accepted wisdom of the time. And it's interesting, it's only really been in the last 3 to 6 months, probably more like 3, that I've noticed in legal press a lot of commentary around the structural changes to the industry. 12 months ago, 2 years ago, it was hardly mentioned at all. So in any event, in 2011, calendar 2011, our board was sort of alive to it, but didn't really know what was going on. So they gave me the job, in addition to doing all the other rubbish they give to me, they gave me the job of investigating what it was that was happening to our industry, identifying what that was going to do in our markets and to our business, and how it was we ought to respond to it and come back to the board with a recommendation. And I spent most of last calendar year, 2012, doing that. And I looked at what's been the history of our industry over a couple of thousand years. What are the things that have happened and influenced it? I looked at what is happening on the client side, the demand side in the Australian market. What are innovators in Australia doing? What's happening overseas in various jurisdictions, and in particular in the UK, and I'll talk quite a bit about the UK today. We've had 3 separate trips to the UK to meet with people and look at different models and see what's happening over there to gain an understanding of what's happening in that particular market. And all of that was sort of drawn together at the end of last calendar year, and our board formed a strategy out of that, which we have been implementing, touch wood, with some success so far this year. So that's sort of how I've come to develop some knowledge of what I'm talking about today. So I think an interesting starting point is, let's have a look at the history of our industry. So from my research and readings, I've extrapolated over the history of our industry where our work has come from and what have been some of the critical inflection points in the development of our industry. And we can trace the origins of the Australian legal industry today right back to Roman times. We probably take it back to Greek times, truth be told. And what I've done is I've characterised the sources of work into 3 buckets. The first bucket is what I call regulated legal work. This is work which, for public policy reasons, society demands only be performed by people who are appropriately qualified and appropriately regulated. The second bucket of work I call unregulated legal knowledge work. This is not work over which we have a statutory monopoly. It is work over which we have an effective monopoly by dint of our knowledge. Throughout the centuries, we have been trained, formally and informally, in law schools and in apprenticeships, if you like, to develop a body of knowledge which is peculiar to lawyers. The rest of society does not have it. because they don't have that knowledge and we do, it has reserved to us a monopoly over certain work. And the third bucket, which is sort of sitting up there, is the last bit, which I call unregulated business knowledge work. We don't have a statutory monopoly over it. It's not, truth be told, really legal work, but it's adjacent to the legal work we do, and we've managed to cleverly throw a blanket over it and claim it for ours. Now, over time, there have been three key inflection points. We would all very, perhaps not fondly, but clearly remember the collapse of the Byzantine Empire in 610, which caused great economic disruption, and with the collapse of the economy, regulatory change to the poor old Byzantine legal profession, which pretty much ceased to exist. I don't think we're going to end up there. The second major inflection point was in 1728 in the UK when the Solicitors and Attorneys Act was passed. It was the first sort of wholesale, significant regulatory change to the profession and an expansion of the regulated legal monopolies. The third inflection point is about now, and it's been going for about 10 years, and I think it's probably going to go for another 10. And there are two things driving it. One is the economic disruption caused by technology, and for us in Australia, the other is regulatory change. And what is going to happen with this, what is happening already, is that the amount of work which was previously reserved to traditional legal businesses will still need to be done. It might be priced differently, might be performed differently. It will still need to be done, but it will not be the sole reserve of the traditional legal business. So, what are the market disruptors that give rise to that inflection point? Principally, there are four. The first is some regulatory change, which is removing some statutory service monopolies, and I'll talk about each of these four points in a little bit of detail. The second is also regulatory change, which is removing the capital monopolies, which until now, or until 2006, reserved in Australia to lawyers the sole right to own a legal business. The third catalyst for change and for market disruption is technology, which is allowing information to be shared and for knowledge to be replicated on a scale and at a pace unheard of until recent times. And the final disruptor is globalisation. Historical borders, which have acted as barriers to competition, are collapsing and allowing competition to wash across different jurisdictions. So they're the four big disruptors driving the new wave of competition in our industry today. So I had the quote earlier of Henry Ford, and if I asked people what they wanted, they would have said a faster horse, and he ignored that and went off and built a new Model T Ford. I think it's interesting for us to just have a look at what happens to some businesses who go down the path of trying to breed or train or buy a faster horse, rather than trying to revive or reinvent their model. So in the US, certainly not the only example, but probably the most high-profile example is Dewey & LeBoff. Now, Dewey & LeBoff was one of the largest, oldest, most successful law firms in the US. To all outward impressions, it was a shining example of law firm success. It had big offices and big clients and big payroll and over 1,000 lawyers across 26 countries. Had all what would perhaps traditionally be seen as the trappings of success, until about May last year when it filed for bankruptcy. The UK is interesting. R3, I'll get this wrong, Tim, you might be able to correct me, it's the Association of Business Reconstruction Professionals. It's the UK equivalent to our Insolvency Practitioners Association here in Australia. Every year they publish a report on different industries, and they explain what the financial risks are facing those industries. The report it published in the last 6 weeks, forecasting out the next 12 months in the UK, identified that 31% of UK legal firms are at financial risk. Now, before you gasp and think that a third of the UK legal industry is about to be washed away, it won't. Last year they forecast 29%. 29% didn't disappear, but a lot did. The SRA is the Solicitors Regulation Authority. It's the equivalent of our Law Society Law Institutes. It's responsible for cleaning up the mess, the ethical and professional mess that is left when a legal business in the UK becomes insolvent. In its budgeting for last financial year, for F13, at the start of the year, it budgeted on the need to intervene in 30 financial failures of law firms. That is, an administrator has been appointed to the business and the SRA has to intervene and clean up the ethical mess. In modelling that's perhaps not dissimilar to some of the modelling our Treasury Department uses here, they revisited it in January of this year and increased their estimate from 30 to 63. I don't know the number that fell out at the end, but I would be surprised if it was less than that number. I can think of about 8 examples off the top of my head of firms of 100 or more staff in the UK who have appointed administrators in the last 12 months or so. That's on the intervention side. Now, armed with that, the SRA has taken a proactive approach to try and prevent that occurring. So it's engaged, rather than intervening, in a preemptive manner with 160 other legal businesses that it's identified as being at risk of financial failure. And these aren't small, little high street two-man shows. 30 of these are top 200 firms in the UK. Size is no immunity from the change that's occurring and the competitive wave that is washing through our industry. So, Australia, we're a bit behind the curve, and I think probably because we have had far more favourable economic conditions. So some of the financial pressures have not been as acute. So the reaction on the whole of the Australian industry to some of these competitive pressures has been the old reaction. You have a freeze on appointment of equity partners, salary freezes, redundancies, the usual sorts of things. If you like, try and save your way to profitability, which, as anyone who's studied a bit of business knows, that you can't do that. It can help delay things, but fundamentally you cannot save your way to success. The interesting question that poses against that broader global picture is what happens in Australia over the next 5 years. And time will tell, but I would expect that in the next 5 years we will start to see, perhaps not to the same scale, but we will start to see the same sorts of things occurring here as have been occurring in the UK over the last few years, with the financial collapse of law firms. It's easy to rationalise all of that sort of stuff as it doesn't apply to me. That's a UK issue, or a US issue, or a big firm issue, or someone else's issue. I think of it a bit like swimming in a pond. We're all happily paddling around in our own little corner of the market. In some cases oblivious to, in some cases just not wanting to know what's happening in the other part of the pool. But in the other part of the pool, there are rocks being thrown in of increasing size and with increasing frequency that are disrupting the market. We don't need the rocks to land on our head to seriously damage our businesses. The waves that are generated from those disruptors hitting the market will wash out. Now, they might only be a ripple today, but the ripples will increase in intensity and frequency, and if we're not prepared for them, they will drown us. So, with that very cheery opening, let's move on to the supply side and what is it that's driving this competition in the market. So, the first is regulatory change. So, in Australia, COAG started to drive regulatory change in the profession back in '94. It took 12 years to get there. I'm embarrassed to say it's actually not even there in our state yet, but that will be changed by September. But that's an excellent sign of how nimble and quick our industry moves, but there we go. Similar time, similar economy, similar culture, similar regulatory regime, similar legal structure. the UK changed its regulatory framework with the Legal Services Act in 2007. So we've sort of been running a bit parallel with the POMs in legal reform, if not in cricket. So the first change has been the change to the regulation of service monopolies. Now, there hasn't been a great deal of change in the UK. The Legal Services Act still preserves to lawyers 6 reserved legal activities. We've trodden a different path here, and it's a subtle, but I think in time it will prove to be an important difference. The new model here moves away from prescribing areas of work which only lawyers can do and talks more generally about the provision of legal services. Now, the relevance of this is that what it does, it creates a regime that can grow and evolve with the economy as the economy develops and evolves. So if you think about the work you did 10 years ago, work which would have been quite legitimately characterised by you and the broader community as legal work, there will be a big chunk of that that you either don't do today or that today is not recognised and accepted as legal work. It might be a business process, it might be something else. The work that you do today, there will be significant chunks of that in 10 years' time which will not be recognised as legal services work. And it will fall out of whatever statutory protections exist for it. So as the market evolves and the economy develops, things which we think today are ours will cease to be. Things which we've never thought of may well come within that scope. So there are opportunities there as well as challenges. The second regulatory change is to the capital monopoly which we've enjoyed for centuries. So we know all about the deregulation there. Now in Australia, it's interesting the different reactions of the UK and the Australian markets. In Australia, the most, not the only activity, but the most public activity has been in the public equity markets. So there was the very well publicised listing of Slater & Gordon, making history as the first law firm in the world to list on a stock exchange back in 2007. ILH Group listed at a similar time, different model, commercial consulting rather than consumer commodity work. And quite interestingly, they've just announced on the stock exchange, just in the last fortnight, I think, that they have agreed terms to buy a couple of financial advisory businesses subject to shareholder approval. And it's a very, I haven't studied it in the detail I'd like, but I'd like to, but on a cursory view of it, it's not with a view to building a financial consulting, financial advisory business. It's with a view to buying and maintaining a distribution channel for their legal product. So it's a different model, it's a different way of thinking. Not particularly radical in the broader economy, but it's a different way of thinking for lawyers. And then, of course, the Shine lawyers out of Brisbane who listed in May and have gone gangbusters ever since. The UK is a bit different. So the Legal Services Act was passed in 2007, but ABSs, or alternative business structures, have only been available since October 11. And the UK industry has moved with remarkable speed since that time. But interestingly, whereas a lot of the capital developments in the Australian market have been in the public capital markets, in the UK it's been far more private equity driven. There's a lot of examples of private equity taking stakes in legal businesses over there and reinvesting. Now, there are examples of listed companies buying legal businesses and bolting into their claims management chain or their whatever else it is. But there hasn't been any sort of greenfields IPO that I'm aware of in the UK. If I were to forecast what will happen over the next 5 years, I would expect that there'd be some sort of equilibrium there. I would expect to see in Australia more private equity activity in legal. And in the UK, I'd expect to see more public equity activity. I don't see any particular reason. The economies are similar enough, the capital markets are similar enough and sophisticated enough that they'll probably sort of balance out. So that's all terribly interesting, but you may sit there and say, well, frankly, I don't particularly care where someone else gets their capital, which is fine, but you should. You should care because the external capital coming into other businesses does not come in unencumbered. The external capital being invested in other businesses is being invested with strings attached to it. And the first string attached to it is that the owners of that capital demand a return. And they don't demand the sort of return that's been tolerated from an indolent legal partnership balance sheet that we've seen over history. They want a real return. A return that warrants the risk and the effort and is at least commensurate with a return which they can generate from other asset classes. Not only do they want a return, but they're going to push to get it. And they can push because they will bring an objective and a dispassionate view of the business into which they're investing and the industry in which they're working. Now, we can all, I'm sure, think of examples where either we or someone else in our business has come up with some cracking idea of how to improve the business. And we skip along to a partners meeting and we share with our partners this wonderful idea. We look around nervously and see the heads starting to nod knowingly and understandingly. I think, beauty, I reckon I'm a shot here. And then there's a little pause, and then someone, sage old head, says, yeah, John, that's quite a good idea. You know, I can see how that would work. But you've got to understand that what I do, it's actually, it's quite special really. It's a bit different to what everyone else does. So you can probably do it with them, but I reckon let's just leave my bit as it is, because it's going along pretty well. Thanks very much. And as a consequence, so many potentially good ideas for business improvement are still born. Not when there's external capital sitting behind it driving the change. They will not accept those answers, and they will have management with them who will ensure that those changes are effective. So think of the ripples in the pond. You're sitting in your little corner, oblivious to the rest of the world. In a far-flung corner, there's an enormous rock being thrown in the form of capital into a business that is driving change. You need to be aware of it, and you need to be very careful about it, because the businesses that are attracting the capital are attracting the resources to invest to make their businesses more efficient and more attractive to the customers for whom you act, and you are going to be competing with them. Technology. Now, I can happily show this quote in this room. If I showed this quote in our office, like anything from about the mid-80s or earlier, I'd be met with half of the office, a sea of very blank faces, because they all seem to have been born sometime after that. But a slightly more mature audience here. I think everyone knows who Gordon Gekko was, not the hero, the villain of the movie Wall Street in the late 80s. He's probably most famously known for his quote that greed is good. The other quote that I think is more relevant to us is his quote that you cannot replace the things that I do with a computer. Gordon viewed himself as an artist. Not a bullshit artist, but he was an artist in his own right. And he carefully crafted his bond trades and all of the things that he did. And it came with his intimate knowledge and needed his thumbprints all over it to make it work. So he couldn't imagine what he did could be replaced by a computer. And it's not a dissimilar attitude or view taken by many in the law. Many lawyers view themselves as the bespoke tailor in a world of crass, cheaply made Chinese polyester knockoff suits. But that's all changing. As it changed for Gordon. So anyone who saw the second Wall Street movie would know that he was released from jail in about 2001 and cut a fairly forlorn figure, traipsing through the gate with no one there to greet him, but he picked himself up by his bootstraps and he went on the speaking tour, in a slightly better paid speaking tour than this one, I think, wrote a few books, and before you knew it, he was back in the game. He'd remade his money, and in 2007, he was ready to go berserk again. But an interesting thing had happened by 2007. In the 20 years after that quote, by 2007, more than half of the trading on the New York Stock Exchange was computer automated. Now, it may be argued with the benefit of hindsight that's not a terribly good thing, but the fact is that it's occurred. The same way that work we did by hand 20 years ago is now automated by computer. The same way that work that we did this week by hand will in 20 years' time, or more likely in 5 years' time, will be automated by computer. And there's a couple of waves in the technological change. The first one we're all familiar with, it's been with us for a long time, and that is the transference and the replication of legal information. And I distinguish between legal information and legal knowledge. So legal information can now be transmitted at scale and at speed, and it's being transmitted to our competitors and to our clients. We all know situations where we have sat up until the wee hours of the morning and slaved over a document that we've rightly taken great pride in because it is a terrific solution to a difficult problem that deals with all sorts of nuances. Off we go, move on to the next job. 6 months later, that magnificent piece of craftsmanship that we slaved over all those late nights suddenly appears back at us, and some other bugger down the road has picked it up from an email trail somewhere, he's copied it and used it. If that hasn't happened to us, then we're probably the one who's copied it and sent it back to its original author. But we've all seen that happen. There's nothing new there. That's life. That's not where the change is. The real change is in the automation of legal knowledge, of legal reasoning. If you think information is static, reasoning is fluid and live and alive. So, there's a really interesting fellow in the UK, in the US, who lectures at the University of Michigan, and he lectures in quantitative legal prediction. And he says that human prediction is a hallmark of the legal services industry, and it's correct. If you think about it in a really simple example, so you're a personal injuries lawyer and Mrs. Jones comes in to see you, her arm's in a sling, she's been battered and bruised because she's fallen over in the Westfield shopping centre. So you sit down with Mrs. Jones and you take a detailed statement and you suck up all the information that you can from her. You then know that to advise her you need other information. So you might get a medical report from a doctor, you might get a report on loss from an accountant, you might get a report from an engineer on the faulty step that you tripped on or whatever it was. And you bring all of that in with your innate legal knowledge. There might have been some recent developments in law. So you research a bit of law and you bring it all in, bundle it into the pot, and out of it you form your advice. Now if Mrs. Jones is lucky, you'll sit down with her and explain it to her in plain English. If she's not so lucky, you'll write a very long letter that you think is very clever but that she doesn't understand. In any event, the advice will be imparted to her. And the advice is a series of predictions. So based on the information that you have collated, with all the qualifications that lawyers always put on it, you sit Mrs. Jones down and say, Mrs. Jones, I predict that if you make a claim against Westfield, you will recover more than $100,000. Sorry, if you make a claim against Westfield, you've got a 60% chance of succeeding. There's prediction one. Prediction two is, if your claim succeeds against Westfield, you will recover more than $100,000. Now, knowing that you're not of any particular means, the price of this I know is important to you. So based on all of my vast experience and superior intellect, I can tell you, I can predict to you that the cost of this exercise will be between $20,000 and $30,000. And the final prediction, which might be relevant to you, Mrs. Jones, because you're now 95, is how long this is going to take to resolve. With my vast experience, I can predict that this will take between 12 and 18 months. Mrs. Jones takes all of that and then decides whether to proceed or not. What has happened is that the lawyer has taken his innate knowledge and specific knowledge he's accumulated, or she's accumulated, and made a series of predictions to the client. And if you actually drill it down to most things we do, you can identify the same thing, a series of predictions. I'm drafting a will for you. If you put this clause in, I predict that that errant son of yours will never be able to get a cent out of your estate, and nor will he make a successful claim. It's a series of predictions. Now, what quantitative legal prediction does is mimics that ability for humans to predict, and it does it at scale. So rather than being able to see 20 Mrs. Joneses in the course of a year, with quantitative legal prediction, that can be done at scale. So 20 Mrs. Joneses becomes 200 Mrs. Joneses. The Washington University, this is over 10 years old, ran a bit of a study to work out whether a computer could do what lawyers do. So it was a collaboration between the law school and the political science department. What they did was built a computer model to predict the outcome of Supreme Court appeals. And then they assembled a panel of legal experts. It was a bit like Kasparov against Deep Blue in a chess game. And they ran that across every Supreme Court appeal during the second term. And the result was that the computer got it right 75% of the time, and the lawyers got it right 59% of the time. Now, I know we can qualify this, and the people in this room could obviously say, well, obviously we're a hell of a lot smarter than those bozo lawyers who did that, and we would have done a lot better than that. Or, you know, they're Americans and they cocked it up, or, you know, we can qualify it any way we like. The important thing is not whether 75%, 59% are the correct percentages. The important thing is that it was done, and that it was done 10 years ago, and that people have been working on this stuff ever since, and refining it and improving it. This is a 2011 decision in the New York District Court, and there are similar examples in superior courts in Delaware and elsewhere in the US, where the courts, ironically, and I don't think there are any judges here, but who I wouldn't sort of put up there as probably the most efficient institutions going around, but in any event, the courts have said to the lawyers, sorry boys, but this is hopelessly inefficient. We're not going to let you do it anymore. We're not going to allow you to assemble rooms of pimply-faced 23-year-old graduates to pour through $10 million at the cost of God knows what in terms of money and delay and time and court time. So what the judge did was commission a customised computer code to identify what was relevant. And rather than the lawyers manually going through, you know, millions of documents each, the computer went through. And out of that, the computer generated the class of documents which would be treated as relevant for the purposes of the litigation. And at that point, the lawyers were free to unleash the pimply-faced graduates on them. It's a classic example of an inefficient, monopolistic market not delivering what the customer ultimately wants, and an external factor correcting that market failure. Quantitative legal prediction has been extended to commercial application. Now, excellently in my preparation for this, I didn't check whether we've got internet connection yet. I made the bold assumption we did. And we're all about to find out whether we do. And we're all about to be quite disappointed. So, let me tell you about road traffic representation. Jot it down and have a look on Google when you get home. Road traffic representation is a simple business. It works through. Does that work? No, that's right. We'll be. Have a look at it when you get home. But
While you're talking?
No, that's right. What it does is it basically process maps out the whole process of a traffic offence. So you can go through the website and click through, answer a series of questions. They're the questions that innately a lawyer knows when they see a client. You've done it 1,000 times, you know the questions to answer. Innately you know when the question, depending on the answer, this is the next spot it takes you to, and you reach your conclusion. This completely automates the process of taking advice on a road traffic infringement. So rather than going and seeing a solicitor and taking advice, you just click your way through the website and answer a series of questions. And it will tell you at the end of it that you can expect to lose your licence for between X and Y months, and you can expect to pay a fine of between A and B pounds. And then you can click on something else. If you really want to speak to a lawyer about it, you can click on something and you'll phone through to a lawyer. He'll speak to you on the phone about it, got all the information in front of him or her, and for a fixed fee of 30 quid or whatever it is, you can get some legal advice on that over the phone. If what you want to do is put a submission in mitigation of your penalty to the court, you click on another button and for another 30 quid or whatever it is, you'll get a template populated with all the data that you've loaded into the website, which will give to you a letter to give to the court saying, I'm terribly sorry, magistrate, I didn't know what I was doing and let me off. Your third option is, well, I'm still a bit uncomfortable with it, I've got a bit riding on this, so I'd actually like someone to represent me, and through the website they can organise for you a barrister to meet you in court. Now, I know the fellow who's established this and runs it, and I think he's done a very good job of it, but I think he would agree it's not the most complicated area of law in the world, and that process mapping it out and automating it is probably a starting point. But the important point is that it is a starting point. And having started, it's now going to move up the value chain. We're not going to be able to stop it. We're not going to be able to say, I'm Gordon Gecko, you can't replace what I do with a computer. A computer, with the resources available to it, the capital to invest, to develop it, can replace much of what we're doing, and it will. So the fourth of those external factors that are driving competition is globalisation. And I won't spend a great deal of time on this because I think we're all familiar with it. The UK have for some time faced an influx of US firms. They have historically, whether they continue to be is another thing, historically been more profitable for some reasons, and that's affected competition in the UK. More recently here in Australia, we've faced an influx of UK and US firms, and that's increased the war for talent right at the top end. Probably hasn't affected it too much further down the food chain. That's an article from the Fin from a year ago. There's 10, I think, in there that have come in. There's probably another 8 or so, I think we can name off the top of our heads that have come in since then. So that's what's happening on the supply side. We've got those 4 drivers of competition on the supply side, the deregulation on service monopolies, deregulation of capital monopolies, technology and globalisation. If it's not enough to cop it on the supply side, we're also getting it on the demand side. Businesses want lower costs. Consumers want lower costs. There's hardly a consumer in Australia who doesn't have a sentimental soft spot for the corner store or for the dairy farmer or for whoever, for the wine producer who's being screwed by Dan Murphy's or by Coles or Woolworths. But it doesn't matter, it doesn't seem to matter how soft that sentimental spot is. They still go to Coles and they still go to Woolies for the down advertising campaigns, and if they can save a few cents there, they'll do it. For whatever reason, and maybe it's always been like this, we live today in a very cost-conscious world, both for consumers and for business. CFOs no longer sit down and write their budgets and say, well, I spent $100 on this last year, CPI is 3%, I'll spend 103 this year. They sit down and say, I spent 100 on this last year, how do I reduce that to 90 this year? And next year I want to get it down to 80. So there's increasing demand by business and by consumers for better, more efficient services. And that's in part propelled by the fact that clients are now better informed than they ever have been before. Part of that is that sharing and transmission of information. Part of it in the business world is the growth of in-house counsels. And I think I'm right in saying that more than a third of lawyers working in Australia are in an in-house role of some description. I think that includes government. So what that does is it creates what I call a virtuous circle of efficiency. There are people now in the market who are innovating. They're either already in the market or they're external people coming into the market. That innovation and knowledge transfer means that clients are better informed. Not only, and as being better informed, they demand more. They demand more innovation, they demand more efficiency, they demand better service, and that in turn feeds more innovation, and so we go on. So if it's not enough to get it on the supply side, we're copying it on the demand side as well. So what does all of that mean to the market? We know that we are in an age of competition which we've not experienced before. But what impact does that have on the market? The Australian commercial mid-market, which is the market that our firm is in and many others, is a good sort of demonstrative example. So call this box the market for commercial services, for services in the Australian mid-market in 2008. It's the box of work traditionally performed by traditional legal businesses. So one of the changes is that global firms have come in. So particularly some of the cross-border stuff that was done by mid-market clients is being chewed off by global firms. So a bit of that's gone. Doesn't mean that others can't perform it, but there's a competitor there who wasn't there before. Some of the national firms are losing some of that, so they start to push down a bit further down into the mid-market where perhaps they weren't before. New business models come in, accountants running their own legal practices, legal process outsourcing, whatever it is, comes in and they chew up a bit of that market. There are new efficiencies, Plexus, Advent Balance, any number of more efficient businesses chew up a little bit more of it. And then finally, we've got the process and the commoditisation chewing up the lower level stuff. So the effect of all of that is that the work which was done in 2008 is still being done. But the bit in 2018 that's reserved to the traditional legal businesses is a lot smaller. Doesn't mean the traditional legal business can't do these bits, can't compete in those bits, but it can't compete using the old model. It needs a new model. So all of that increase in competition drives market segmentation, and we're seeing it happen now. And it's happening at two levels. There's vertical segmentation happening in legal specialisations, which I broadly characterise segmenting itself into consumer law, commercial law, and what through nothing other than a lack of imagination I've called other. On the horizontal front, the market is segmenting itself into business types, not into legal specialisations, but into business types, into what we call process work, commodity work, and consulting work. Now, the distinguishing features between them are primarily price and legal expertise. I think you could add volume to that, but I struggle enough with a graph with two axes without trying to add a third one into it. So what we see is that the consulting work generally, the delivery of it generally requires much greater expertise and therefore commands a higher price. The legal process work to be delivered requires next to no legal expertise. Now, it may require legal expertise to build the model, but it doesn't require legal expertise or a great deal of legal expertise to actually deliver the service out of that model. And the lower the expertise, unsurprisingly, the lower the price. And the commodity work sits in the middle, which does require a level of legal expertise to deliver it, but it's generally expertise that can be readily replaced. So having a look at how that sort of splits itself up, this is just a bit of a snapshot of some of the businesses that have carved a spot out for them themselves in those different market segments. I talked about road traffic representation, My Will Online. I don't think you need to be a rocket science to work out what they do. ClearDocs we're familiar with. I think they're still owned by Maddox, aren't they? So they've sort of produce commercial documents and other documents. A couple of interesting ones in the UK. Quality Solicitors, I sort of describe that as the H&R block of legal. So there's a plethora of what are called high street firms, to us sort of small suburban firms in the UK, and they don't have the resources or the expertise to reinvent themselves to deal with the challenges brought by this new competition. So Quality Solicitors is a brand, it's a franchise. It's a brand that you can use, and what comes with it, there's some really, have a look on YouTube at the Quality Solicitors ads, there's some really schnick ads they've got. But you can get some precedents and training and things that you might not be able to develop yourself. So that's another model. Stobart Barristers is another interesting one. Stobart, is it Stobart or Stobart? Stobart. It's a trucking company that set up a legal business. In the first instance, it's effectively virtual barristers' chambers, and they've just been licensed to set up a solicitor's legal business. If you think of it in an Australian context, it'd be like Lindsay Fox setting up his own legal business. Lynn Fox Legal, that's what these blokes do. And then in the consulting end of it, I've shamelessly given our firm a plug there. Pete McGee's crew at Armstrong Legal, consulting in the consumer space, top end stuff. Gilchrist Connell is another interesting one out of Adelaide. It's a pure insurance practice that was part of Thompson's, which is an Adelaide firm that's grown quite quickly nationally. But what Thompson's and it's not Adam Gilchrist, but Steve Connell and Kevin Gilchrist identified was that effectively oil and water don't mix. So they amicably agreed to part company. Gilchrist Connell was set up as a specialist insurance practice that now has a national footprint. It's a very successful business, but it's successful because it's picked a spot in the market and has become very, very good at it. And Thompson's didn't make the mistake of trying to be all things to all people. Now, I couldn't actually think off the top of my head of an example there. If someone's got one, let me know, because I think that'd be quite a good business opportunity. So, that's what's happening with the market. So, what do we and other businesses do? I think we have to ask ourselves with some brutal and uncustomary honesty 4 questions. And the first of those questions is, why do I exist? And not in an existential sense. Why do I exist professionally? Why is it that I'm in this game? Now, there'll be some people whose answer to that is, I'm in it because I just like being a lawyer. I've really got no interest in all this business stuff. I just want to be a lawyer. I love the way that I've practiced for the last 20 years, 30 years, and I just want to keep doing it. And that's fine. It's an absolutely perfectly legitimate answer, and there's no reason to change. I think your revenues will decline, I think your profitability will decline, but if you're prepared to accept that, it's perfectly legitimate to keep going, knowing what the consequences of that are. If, however, your view is different, if your view is, I don't just want to survive or wither, I want to survive and I want to thrive, then there are 3 consequent questions that need to be addressed. And each of them are actually very, very difficult. They're difficult ones to answer, and they're even more difficult ones to implement. And the first question is, who sets the standards in the business? Are you going to be dictated to by the highest common denominator or the lowest common denominator? Are you going to allow people to make decisions and behave in a way that might suit their personal preferences, but is contrary to the interests of the business as a whole? If you are truly going to thrive in this new competitive industry, you cannot do that. They simply will not coexist together. The second is your business structure. I won't go through all of that, save for 2 points. One is, as a commercial business structure, I think partnerships are fundamentally flawed and companies are vastly superior. Leaving that aside, psychologically, I think the partnership structure is a really difficult one because it brings with it so many expectations which are about involvement in management, about rights to capital and all sorts of things which allow for the interests of the individual to supplant the interests of the group or of the business. The legal entity is not the be-all and end-all. It's getting all of those things right, and you can get all of those things right within a partnership structure, but I just think it's jolly hard, and effectively your capital is a lot more expensive in there. There's going to be a lot of speakers today talking about IT, about pricing, about partnership remuneration, about all sorts of things which are all relevant to this issue of service delivery. And there's a whole range of decisions that need to be made around structures on that side, which I won't go into. And the final question is, what is my market segment? You need to choose a market segment. And when you're choosing a market segment, remember that segment is singular. Choosing a market segment does not mean I'm going to straddle 6 of the 9 boxes. It means in this day and age, choose a segment that you're really good at and get rid of the rest of them. Do what Thompson's successfully did with Gilchrist Connell, and stick with what you're particularly good at. So all of that, we come back to dear old Henry, and at its heart, I believe to survive and to thrive, as distinct from to exist or to wither, to to survive and to thrive in the new age of competition that we're facing, it does need a new model. If you're simply trying to coax the old horse to go a bit faster, you might get him a bit faster for a furlong or two, but he's going to run out of puff eventually. So I will leave you with that. Thanks very much.